Hi guys! So, this is the last installment of a 4-part video presentation I will be making for our legal ethics subject. And in this 4th video, I will be discussing canons from 14 to 22, which will cover the duties of a lawyer to his clients. Canon 14. A lawyer shall not refuse his services to the needy. For canon number 14, we can take, for example, the case between Samar Mining Corporation versus Arnado, Tan, and Abuyan. In this case, Rufino Abuyan serves as a foreman with the petitioner Samar Mining Corporation, and while he was employed with the petitioner, he allegedly contracted a disease. Thereafter, he filed a civil case against Samar Mining Corporation and was referred to Pompeo Tan, an officer of the regional office of the Department of Labor, and Tan sentenced the petitioner to provide continued hospitalization and medical treatment to Abuyan, to pay Abuyan the lump sum and weekly compensation until he is completely healed, and to pay the workman compensation funds as administrative costs. Because of this, the lawyer of Samar Mining Corporation, Attorney Benedicto Arcinas, filed an action for certiorari against Francisco Arnado as regional administrator of the said office, Pompeo Tan as the writer of the said decision, and claimant Abuyan. According to Attorney Arcinas, Tan had acted without jurisdiction in hearing the said case and rendering decision thereon, because he was just a mere labor lawyer. The Court of First Instance Cebu dismissed the petition of Attorney Arcinas. Despite the judgment of the court, in the case between Rufino Abuyan versus Samar Mining Corporation, the petitioner's counsel still pursued the case, claiming that the lower court committed an error in judgment. So, the issue here is whether or not Attorney Arcinas delayed the proceedings of the case. Yes, the petitioner has succeeded in prolonging the litigation of this case, especially regarding the payment of the compensation for Abuyan, which must had been given 12 years ago. It is a manifestation that the purpose of this case has been merely to delay a policy often resorted to as a means of draining the resources of a poorer party and compelling it to submit out of sheer exhaustion. Thus, the conduct of the petitioner's counsel is hardly compatible with the duty of the bar to assist in the administration of justice and not to obstruct or defeat the same. Canon 15. A lawyer shall observe candor, fairness, and loyalty in all his dealings and transactions with his clients. For canon number 15, let's take for example the case between Rocassia versus Bulalakaw. Rocassia, the president of TACMA Philippines, filed a disbarment case against Attorney Benjamin Bulalakaw. In this case, Attorney Benjamin serves as a legal counsel with TACMA Philippines. However, after the termination of their lawyer-client relationship, it appears that Attorney Bulalakaw accepted to represent the employees of his former employer, which is TACMA Philippines, and stand with them and filed a complaint before the National Labor Commissions and appearing in their behalf. So, the issue of this case is whether or not Attorney Bulalakaw breached his oath of office by representing the employees of his former client. Yes, Attorney Bulalakaw breached his oath of office. The court reiterates that the loyalty of a lawyer to his client does not end upon the termination of their client-lawyer relationship. Attorney Bulalakaw was suspended for 3 months from the practice of law. Canon 16. A lawyer shall hold in trust all monies and properties of his client that may come into his possession. For canon number 16, let's take for example the case between Nadayag versus Grajeda. Nadayag seek for notarization from Attorney Grajeda on a pacto de retro of an original certificate of land title. The same document was confiscated by the Registry of Deeds, Attorney Baguio, upon the application of the Dayag's pacto de retro. It was found out that several cases of stolen original certificate of land titles have been taken place in the said office. Only the Registry of Deeds has an authority to keep the original certificate of land title. So the issue in this case is whether or not the respondent, Attorney Grajeda, is violative of Canon 16 of Code of Professional Responsibility. Accordingly, and as recommended by IBP Board of Governors, the court resolved to suspend Attorney Jose Grajeda from the practice of law for a period of 3 months. A lawyer shall at all times uphold the integrity and dignity of legal profession. A bar shall maintain a high standard of legal proficiency as well as of honesty and fair dealings. Nothing should be done by any member of the legal fraternity that might lessen in any degree the confidence of the public and the fidelity, integrity, and honesty of the legal profession. Canon 17. A lawyer owes fidelity to the cause of his client, and he shall be mindful of the trust and confidence reposed in him. The Javeliana versus Lutero case is one good example we can take for Canon number 17. In this case, the Roman Catholic Archbishop filed a detainer complaint against Elpidio Javeliana with the Metropolitan Trial Court of Iloilo City, presided by Judge Nicolas Lutero. The first 2 hearings was postponed because Javeliana did not receive a copy of the summons, and another 3 hearings were postponed because the lawyer representing Javeliana, who is Attorney Hotia, said to have other business in Manila, and in one of the occasions he said that he hurt his right toe. The last postponement was granted with a warning that no further postponement will be entertained. When the case was called for trial again, both Javeliana and his lawyer were absent. The hearing proceeded and the judgment was rendered against Javeliana. Javeliana filed a petition for relief with CFI. His counsel, on the other hand, tried to justify his absence. The trial court dismissed the petition of Javeliana. So the issue in this particular case is whether or not Attorney Hotia served his client with utmost competence and diligence. The answer is no. Attorney Hotia did not serve his client Javeliana with utmost competence and diligence. A counsel for any party in a judicial controversy is duty-bound to prepare for trial with utmost diligence and deliberate speed, regardless if the case is a simple or uncomplicated one. The fact that the trial was set for 6 times means that Attorney Hotia missed this aspect of his duty. A counsel must give preferential attention to every case that he handles. This attitude of Attorney Hotia is censurable because it shows disrespect to the judiciary and the machinery of justice. Canon 18. A lawyer shall serve his client with competence and diligence. For Canon number 18, let's take for example the case between Ramos versus Jacoba. In this case, complainant Severino Ramos and his wife were the defendants of a civil case for a collection of money before RTC of Cabanatuan City. Since the judgment was against the spouses, they engaged the services of Attorney Elise Jacoba and Attorney Olivia Velasco Jacoba as counsel for their appeal before the CA. However, despite the 135 days of extension, their counsel failed to file the appellant's brief, resulting to the dismissal of their appeals. The motion for reconsideration was also denied. The spouses Ramos then filed a verified complaint against their counsels before the commissions of bar disciplines and prayed for the disbarment of Attorney Ellis and admonishment of Attorney Olivia. The respondents were required to answer the complaint but neither complied. It was also found out that this is not the first offense of Attorney Ellis. There was an instance where he failed to file an action to recover the possession of property despite the lapse of 2.5 years. He was then suspended for 6 months and was told to return the sum of money he received from his client Liberato Sorano. So the question here is whether or not Attorney Ellis violated the Code of Professional Responsibility. The court held that Attorney Ellis has not learned his lesson. He was found to be in violation of Canon 18.03, which says, "A lawyer shall not neglect a legal matter entrusted to him, and his negligence in connection therewith shall render him liable." Thus, the recommended 6 months suspension was increased to 1 year, and he was ordered to return the money he received from spouses Ramos. As regards to Attorney Olivia, the records shows that her participation was limited to the assistance she rendered in filing the notice of appeal before the trial court. The court did not find basis for sanctioning her. Canon 19. A lawyer shall represent his client with zeal within the bounds of the law. For Canon number 19, let's take for example the case between Peña versus Attorney APARICIO. In this case, Attorney Lolito APARICIO served as a legal counsel for Grace Hufana in an illegal dismissal case that she filed before National Labor Relations Commissions against Fernando Martin Peña. Hufana is praying for a claim for separation fee, but Peña rejected the claim as baseless. Thereafter, Attorney APARICIO sent a letter to Peña reiterating his client's claim for separation fee. Through his letter, he threatened Peña that they will be filing for bigger claims against Peña if he fails to give them the settlement that they are asking. Attorney APARICIO said that he would claim for bigger amounts, including moral damages, as well as multiple charges such as tax evasion, falsification of documents, and cancellation of business license to operate due to violation of laws. So the issue for this example is whether or not Attorney APARICIO violated Canon 19 of Code of Professional Responsibility in joining every lawyer to represent his client with zeal within the bounds of the law. In the case at bar, the case was not only violative of Canon 19 of Code of Professional Responsibility, but they also amount to blackmail. Attorney APARICIO was reprimanded by the court. While the writing of the letter is considered to be against ethical standards, the court held that disbarment is too severe a penalty to be imposed on the respondent, considering that he wrote the letter out of overzealousness to protect his client's interest. Canon 20. A lawyer shall charge only fair and reasonable fees. To better understand Canon 20, let's take for example the case between Del Rosario versus Court of Appeals. Del Rosario filed a case against the Jos Marikina Transportation Company Incorporated for the physical injury he sustained because he fell from and was dragged along an asphalt road by a passenger bus operated by the transport company. The incident happened when the bus driver bolted forward in high speed, causing the petitioner to lose his grip and balance. The trial court rendered judgment in favor of the petitioner. On appeal, the Court of Appeals affirmed in toto the decision of the trial court but lowers the attorney's fee. An appeal for the decision of the CA was filed but then denied, and thus the petition or this petition was submitted. So the issue here is whether or not the reduction of the attorney's fee by the appellate court is an error on the latter's part. The answer is yes. The reduction of the attorney's fee by the appellate court is an error on the latter's part. The Supreme Court found that the trial court's rewards on the attorney's fee was reasonable considering the difference of the time frame from the filement of the case up until the rendition of the judgment, which took 4 years and 6 months. Also, the appearances no less than 20 is considered. Wherefore, the instant petition was granted and the decision of the appellate court was modified and the judgment of the trial court was reinstated. Canon 21. A lawyer shall preserve the confidence and secrets of his client even after the attorney-client relation is terminated. The JANITO versus Attorney SILAPAN's case will help us understand Canon 21. Attorney SILAPAN was leasing an office in JANITO's building. He was also handling some of JANITO's cases. After a while, Attorney SILAPAN borrowed money from JANITO so he can buy a car. Attorney Sinapan issued some post-dated checks, but these checks was dishonored. JANITO then filed a case of BP 22 against Attorney Sinapan. In his defense, Attorney Sinapan alleged that JANITO is involved in selling and buying deficiency taxed imported cars, shark loans, and other shady deals. He also claimed that JANITO was involved in bribery cases. JANITO then filed a case against Attorney Sinapan, indicating that the lawyer was guilty for breaking their client-lawyer relationship. So the issue here is, was Attorney Silapan guilty of the breach? Attorney Silapan was suspended for 6 months. It was improper of him to disclose those information as these were not the subject matter at hand for the litigation. His professional competence and legal advice were not attacked in this said case. A lawyer must always conduct himself with integrity. Canon 22. A lawyer shall withdraw his services only for good cause and upon notice appropriate in the circumstances. Let's take for example the case between Venturez versus Cosme. Venturez and friends hired attorney Cosme on a land title dispute. The court ruled against the complainant. They wanted to file for motion for reconsideration, however, attorney Cosme refused or failed to do so. Because of this, the complainants were constrained to contact another lawyer to prepare the motion for reconsideration. Attorney Cosme claimed that the son of one of the complainants informed him that the complainants are withdrawing the case from him and that the son has already contacted another lawyer. Attorney Cosme further explained that he turned over the files about the case to the son and that he ceased to be the counsel of the complainant. So in this case, the issue is whether or not attorney Cosme violated the Code of Professional Responsibility. The Supreme Court finds that the respondent is guilty for violating the Rule 22.01 of Canon 22 of Professional Code of Responsibility by abandoning his client without good cause. An attorney may only retire from a case only by a written consent from his clients or by permission of the court after due notice and hearing, in which event the attorney should see to it that the name of the new attorney is recorded in the case. The Supreme Court then suspended the respondent or attorney Cosme for 3 months from the practice of law.